Bismillahirrahmanirrahim. Learned members of the bar and the bench, indeed it's a great pleasure and privilege for me to be with you people, though at far distance, to share with you on the subject. Today's subject is discharge and cancellation of the case. Primarily, the topic mainly relates to the assignment which is being done by the judicial magistrates, involvement of the law officers as well as the learned members of the bar cannot be questioned. So far as the discharge of the accused and cancellation of the case is concerned, we will examine the different case law and eventualities on following classifications. First is, what are the relevant provisions of law on the subject? Then the literal meaning of the discharge and cancellation of case. Third one is power of police to investigate, arrest and release. Next is the legal meaning of both the expressions. Next one is the scope of section 63, 169, 170 subsection 1, 173 subsection 3 of the Code of Criminal Procedure 1898. What is the difference between the discharge and cancellation of case? And then the next topic would be the effect of discharge and cancellation. We will also share views, though in brief, the magistrate's power to discharge or cancel the case, cases of double jeopardy is another subject which will dilate upon which we will dilate upon, and then what is the status of the magistrate while discharging accused or cancellation of case. Ladies and gentlemen, first of all, I tell you the relevant provisions. As I told you earlier, there are 5 provisions in the Code of Criminal Procedure which deals with the subject. Number 1 is section 63, 169, then 170 subsection 1, though not directly on the issue. Then section 173 subsection 3 is also relevant with reference to the discussion, and Chapter 11D of Volume 3 of High Court Rules and Orders, and then Rule 24.7 of the Punjab Police Rules 1934. What is the meaning, literal meaning of the discharge? As both the expressions have not been defined in the definition clause, so according to the concise Oxford Dictionary 9th edition, the discharge means let go, release from duty, committed, confined, dismissed from office and employment. And according to Black's Law Dictionary, to release, liberate, annul and unburden. While the expression cancellation means withdrawal or revoke, discontinued or delete. These meanings are very relevant and material in order to understand the scope of both the words and the expressions, and will be helpful for us to know the effect of both the expressions when a person is discharged or a particular case is cancelled. As all of us are well aware and conscious of the fact that in the criminal administration of justice, there are 3 or 4 stages, right from the registration or lodging of the FIR. And undeniably, the first stage is the registration of a FIR by the aggrieved persons. With this aspect of the case, we are not concerned, keeping in view the topics and subject under issue. The second stage is commencement of investigation. Third one is arrest of the person. Fourth is cognizance of the case. Second and third steps are relevant so far as our subject is concerned. When the investigation is commenced and started by the investigating officer, as you are well aware and conscious that in the definition clause, the word investigation means to collect the evidence on a particular issue with reference to the culpability or otherwise of the person against whom there is an allegation or accusation. Gentlemen, there are 2 provisions so far as the discharge of the case is concerned. Number 1 is Section 63, read by Section 169, and another provision is Section 157, subsection 1, Clause B. Though I am not reading the whole sections, but in order to give you the better understanding, it would be desirable to deal with in brief, first of all, the Section 63. What does it say and what does it mean? Section 63 with the heading Discharge of a person apprehended, and it says no person who has been arrested by the police officer shall be discharged except on his own bond or on bail or under the special order of the magistrate. Now, simultaneously, we see what Section 157 subsection 1 says, and then we will see what is this impact of Section 169 of the Code of Criminal Procedure. Section 157 subsection 1 Clause B, though categorically and directly does not deal with the discharge of the accused, but it suggests that if the investigating officer or the SHO, whatever the case is of the opinion that there is no sufficient reason to proceed with the case, meaning thereby to conduct the investigation, then while formulating the opinion not to conduct the investigation, he will submit a report to the Ilaka magistrate with the reason for not doing so. This is only Section 157. Now we come to Section 169, and Section 169 says release of accused when evidence deficient. If upon an investigation under this chapter it appears to the officer in charge of the police station or the police officer making the investigation that there is not sufficient evidence or reasonable ground of suspicion to justify the forwarding the accused to the magistrate, such officer shall, if such person in custody released him on his executing a bond with or without sureties, or such officer may direct to appear it, and when so required, before a magistrate empowered to take cognizance of the offence on the police report and try to the accused or send him for trial. Also, I will make reference to section 173 subsection 3. Though section 173 envisages the submission of the report, which is known as challan in the language of the police rule, but subsection 3 says whenever it appears from the report forwarded under this section that the accused has been released on his bond, the magistrate shall make such order for the discharge of such bond or otherwise as he thinks fit. These are the provisions directly or indirectly concerned with the discharge of the accused. So far as the Chapter 11D of the Volume 3 of the High Court Rules and Order is concerned, it deals with the cancellation of the case, and at appropriate stage I will let you know the provisions contained in the Chapter 11D so far as the cancellation of the case is concerned. Now we have the different provisions with reference to discharge of the accused, and the question is now how a person can be discharged, what are the circumstances and what are the reasons whereby a person can be discharged though nominated in the FIR. Comparative examination of section 63 read with section 169 of the Code of Criminal Procedure 1898 envisages that there are three modes of file in order to discharge the accused. Number one is on his bond, number second on his bail, and number three special order of the magistrate. Section 169 further stipulates that when evidence is deficient or there is a non-availability of the reasonable grounds of suspicion to justify forwarding the accused. Now we have to see these are the two reasons in order to discharge the accused. Number one is the deficient evidence, or in other words insufficient evidence, and the other one is non-availability of reasonable grounds of suspicion of to justify forwarding the accused to face the trial. Now the question is, what is the meaning of insufficient evidence and reasonable grounds? Again, this expression we won't find any definition and clarification in the Code of Criminal Procedure. In Black's Law Dictionary, the expression has been defined such cause as to hold defendant to answer charges, adequate evidence, such evidence in character, weight, as well justify the judicial action demanded. And one thing more, we have stated the reasonable grounds to create suspicion not to forward the case to the magistrate के अल्फाज इस्तेमाल हुए हैं. यहाँ पर ये नहीं है कि वो जो एविडेंस इकट्ठी की गई है वो उसकी कन्विक्शन के लिए जरूरी है. मीनिंग thereby कि if the investigating officer coupled with the station house officer are of the opinion that the evidence collected are available with the complainant are secured during the course of investigation at the initial stage or even at the later stage is not sufficient and insufficient evidence, then both the provision of law, meaning thereby the section 69 and 163 permits, coupled with section 167, permits the SHO or the investigating officer to release the accused on bail. For example, what is the insufficient evidence? Murder case, taking the example of the murder case, A has been leveled allegation of abetment of murder. accept allegations in the FIR that such and such occurrence has been committed at the instance of A, who is the abettor. No other evidence is available on the record. The eyewitnesses and the other witnesses who associated themselves in the investigation got recorded their statements under section 161 of the Code of Criminal Procedure, also did not utter even a single word on the subject. Now we got one sentence, and that is contained in the report under section 154. ये कत्ल A के ईमा पर हुआ है. What is the effect and the consequences of this sentence? We are discussing the meaning of and the implications of this sentence, not with reference to conviction or acquittal of that particular person if he faces the trial. We are concerned here with the discharge of the accused, whether, in other words, whether it is in the competence and domain of the investigating officer or the Ilaka magistrate to discharge the accused by a special order as contained in section, both the sections which I have enumerated earlier, with the on the application of the accused, on the application of the investigating officer. It is clear that except one allegation, there is no other evidence at all in order to connect the A in the offense of abetment. Now, keeping in view the allegation and the evidence, it will be well within the right of the SHO or the investigating officer to release the accused after getting a bond in order to appear before the Ilaka magistrate as and. One thing I must say, that in order to discharge the accused, question of probability of conviction is not a moot point. The next thing is that evidence of the parties, meaning thereby the prosecution or the defense, is also not required to be put in juxtaposition for the purpose of discharge of the accused. मिसाल के तौर पर, A is the nominated accused with the allegation of murder of B. He takes the plea of alibi, produces 5 or 6 witnesses in order to substantiate the plea of alibi, adding that on such and such date, at such and such time, meaning thereby at the time of the occurrence, he was at place P and was not present at the place of occurrence. The evidence produced by the accused, though appears to be convincing and worthy of credit, but for the purpose of discharge, now the investigating officer has to evaluate the evidence which does not fall within the domain of the investigating officer. It is for the court, and the court, which court? The trial court, to evaluate, to assess the evidence produced by the prosecution and the accused in defense. So in this particular proposition, in this particular example, neither it will be within the domain and the right of the investigating officer, nor it will be within the power of the magistrate to discharge the accused if the application is made. In section 169, we have seen that the expression special order of the court, a special order of the magistrate has been used. What does it mean and does it indicate? I have told you that it is the power of the SHO and the magistrate as well. If the SHO or the investigating officer does not take any risk to discharge the accused, then he can make an application to the magistrate for discharge of the accused, highlighting the reasons of his conclusion about the discharge of the accused. And what is the job of the magistrate? To go through the police file, examine the evidence collected during the course of investigation by the investigating officer from the prosecution side. The evidence produced by the defense cannot be taken into consideration either by the investigating officer or by the SHO or by the magistrate in order to pass a order to discharge the accused. Similarly, in an injury case, B is the complainant who is the eyewitness of the occurrence as well. He is the first informant, got the FIR lodged against the Z, leveling allegation of making assault upon the B, causing injuries on his abdomen. Statement of the injured was also recorded, who did not implicate the accused as accused by the complainant in the report under section 154 of the Code of Criminal Procedure. Now this is the eventuality different from the earlier one. The complainant no doubt is the eyewitness, but the injured is always considered a star witness of the prosecution. All the witnesses say that A has committed the offense, A has injured the B, but the person upon whom assault has been committed does not make any reference of the assault committed by the B upon him. So in these circumstances, the question would be whether there is sufficient evidence within the meaning of the provisions which I have read earlier in order to make discharge of the accused, or he has to face the trial. Next question would be that what should be the order? If the magistrate agrees with the report of the investigating officer duly forwarded, then he can make an order to discharge the accused. Otherwise, if there are more than one accused, will make an order to submit report under section 173 of the code, and after receiving the report under section 173, whether the accused has been placed in column number 2 of the report, shall forward the accused to the court of competent jurisdiction for trial. Now, the next important question is, what is the difference between the discharge and cancellation of the case? Literal meaning of the discharge and cancellation I have told you. Mind you that the discharge of the accused doesn't mean acquittal of the accused. It doesn't mean the termination of the prosecution or the proceeding in the criminal administration of justice initiated on the strength of the report under section 154 of the code. It just gives an option and a right to the magistrate or the investigating officer to put the release of the accused for the time being or till the submission of report under section 173 of the Code of Criminal Procedure, putting that particular accused at the mercy of the court, placing him in column number 2 of the report under section 173 of the code, giving option and discretion to the trial court either to call him or not call. This aspect we will also deal at the appropriate stage. As I told you that discharge of the accused is not an acquittal of the accused. It is not termination of the proceedings against that particular accused. It is just ریلیز آف دی کسٹڈی، پولیس کسٹڈی سے اس کو ریلیز کر کے بانڈ پہ اس کو چھوڑ دینا، یہ ہے ڈسچارج کا جو لیگل میننگ ہے. جیسا کہ ہم نے کہا کہ ہم پہلے لٹرل میننگ دیکھتے ہیں پھر لیگل میننگ. تو لیگل میننگ میں ڈسچارج آف دی ایکیوزڈ مینز ریلیز آف دی ایکیوزڈ، بٹ اٹ ڈز ناٹ مینس termination of the proceedings. It also does not mean the acquittal of the accused. اس پہ سب سے پہلے میں آپ کو 2-3 اتھارٹیز تو بہت ہے اتھارٹیز بتاتا ہوں. PLD 1987 لاہور 236 نذیر احمد ورسز دی اسٹیٹ. Then طالب حسین and another versus Muhammad Aslam and other 1997 Pakistan Criminal Law Journal 56. The next one is Rahmat Ali versus Nazir Hussain 1997 MLD 1135. Waqarul Hassan Ilyas Mittu and another versus the state PLD 1988 Lahore 336. PLD 1949 Lahore 537, PLD 1965 Lahore 734, 1985 SCMR 1314. There are chain of authorities on this subject, and I do not want to burden you with more case law on this subject. However, I will make reference to the alumnious judgment Ashok Hussain versus Session Judge Lodra and 3 others, and that citation is PLD 2001 Lahore 271. اس کا جو ایک پیرا جو ہے وہ میں آپ کو بتانا چاہوں گا تاکہ آپ کو جو میں نے بتائے ہیں کہ ڈسچارج کے امپلیکیشنز ایفیکٹس اور کیا ہوتے ہیں وہ اس میں لاہور ہائی کورٹ نے ڈسکس کیا ہے. The resume of the statutory provision referred to above is that word discharge appearing in section 63 and subsection 3 of section 173 of the code has been used in context of releasing an accused person from custody. Under section 63, an arrested persons can be discharged by a police officer upon execution of a personal bond by such an accused person, or he can be discharged on bail or under the special order of the magistrate if such an accused person undertakes to appear before the said police officer, a magistrate or a trial court, if and one required to do so. Making reference to the provisions of section 173 subsection 3, it was held under subsection 3 of section 173, a magistrate seized of a police report under clause A of subsection 1 of section 173 may discharge an accused of his bond who has not so far been released on the basis of bond cannot be discharged by a magistrate of his bond under subsection 3 of section 73 of the code. It is further evident from the above resume of the relevant provision of the code that the power to discharge an accused person on the basis of a bond during an investigation rests with the police officer, the court granting bail, or a magistrate under section 73. An accused person may also be released on the basis of bond by officer in charge of the police station or the investigating officer under section 69 or upon taking security of a case. ایک دو چھوڑ کے پھر آگے, the power to discharge him of such bond rests only with the magistrate seized of a police report under section 173 and the said powers of the police officer and the magistrate. Absolutely nothing to do with the question as to which court would ultimately have the jurisdiction to try the offence. So as I told you that discharge of accused is the release of the accused from the custody and it does not amount to acquittal of the accused. اب اس کا होगा नतीजा क्या निकलेगा। अब हम इसको पढ़ने के बाद, और जो मैंने PLD 2001 लाहौर आपको बताई है और जो दूसरी साइटें बताई हैं, उनमें जो उनसे जो फोकल पॉइंट्स डिड्यूस किए जा सकते हैं, वो मैं आपको 4-5 पॉइंट्स जो हैं वो मैं आपको इसके साथ शेयर करता हूँ। नंबर 1, ऑर्डर ऑफ डिस्चार्ज denotes release of a person from custody made under section 63 and 169 and section 169 of the Code of Criminal Procedure 1898. Number 2, it does not bar investigation agency for investigation and re-investigation. Number next, it just requires permission of magistrate in case of re-arrest of accused. The next one again, police officer can re-investigate and place the discharge accused either in column number 2 or in column number 3 of the report under section 173 of the code. The next one is discharge of the accused does not amount to an acquittal of the accused. And the next one, it does not mean termination of the prosecution. These are the 6 focal points which flows from the discharge of the accused. 2 or 3 points are required your attention and consideration. After the discharge of a particular accused, the question is whether a re-investigation can be made or not, and if it can be made, how the police officer can make the re-investigation. The case law, including PLD 2001 Lahore and the other which I have referred you, highlights and enunciates the settled proposition of law that discharge of the accused does not put a bar and cloak on the investigating officer to re-investigate the matter, and the permission or the assent of the magistrate is not a condition precedent in order to re-investigate the case. जो एविडेंस उस वक्त में मौजूद थी उस पे तफ्तीशी अफसर ने या SHO ने एक ओपिनियन फार्मुलेट की या खुद उसको रिलीज कर दिया या ऑर्डर करवा लिया मैजिस्ट्रेट से ऑन दिस ग्राउंड। अब एक बात यहां पर और भी देखने वाली है कि जब मैजिस्ट्रेट के पास आएगी और मैजिस्ट्रेट ने एक स्पेशल ऑर्डर करना है तो उसके लिए जरूरी है कि मैजिस्ट्रेट एविडेंस को देखेगा कि जो एविडेंस कलेक्ट हुई है उसका इंपैक्ट क्या होगा, वेदर इट इज अ सफिशिएंट एविडेंस और वेदर इट इज देयर इज अ रीजनेबल ग्राउंड टू क्रिएट अ सस्पिशन फॉर नॉट फॉरवर्डिंग द अक्यूज टू द मैजिस्ट्रेट फॉर फर्दर प्रोसीडिंग्स, एंड आफ्टर एवेल्युएटिंग द एविडेंस वो जो इस पे करेगा। अगर मैजिस्ट्रेट या पुलिस ऑफिसर उसको मुल्ज़म को डिस्चार्ज कर देते हैं तो री इन्वेस्टिगेशन के लिए किसी भी इजाजत की जरूरत नहीं है। अनडिनाइबली द इन्वेस्टिगेटिंग ऑफिसर shall record a zimni in case diary to the effect that earlier such and such evidence was available with the police, and since there was no sufficient evidence at all, therefore the investigating officer or the SHO or through the courtesy of the magistrate, the man was discharged. However, later on the complainant has produced the evidence involving that discharge accused prima facie in the commission of the offence, so it is in the interest of justice that re-investigation should be conducted. By making this order in case diaries, he can re-investigate the case without the formal permission of the magistrate. Whether the order of discharge was made by the magistrate or by the investigating officer, the authority which made the order of discharge is totally irrelevant and immaterial so far as the re-investigation of case is concerned. However, if the accused has been discharged for the purpose of re-arrest of the accused, permission of the magistrate is essential. For arresting the accused, magistrate's permission is required, but not for the purpose of reinvestigation. اچھا یہ جو تھا یہ ایک ویو سیٹلڈ ہے، لیکن اس میں کانٹریری ویو بھی آئے، میں وہ بھی آپ کے سامنے شیئر کرنا چاہتا ہوں. اس میں کانٹریری ویو میں 1983 پاکستان کرمنل لا جرنل 2187 دس از ون. دا سیکنڈ ون PLD 1986 لاہور 81 یہ، اور اس کے بعد 1987 MLD 2